Okay, let's go on the record on cause number DC 196309, Maya Walnut versus Brian Lee. Counsel, make your appearances.
Yes, Your Honor. Ann Johnson, Mary O'Connor, Chris Knight, and Alicia Pitts for the defendants.
And Ira Bowman is here on behalf of the plaintiff, Your Honor, along with Monica Nowairowski and Samantha Baines.
Okay, let's go ahead and proceed.
Your Honor, we're here today on our objections to the judgment. I know we don't have a lot of time, and I think we can do this fairly quickly. To just bring the court up to speed on, since we last spoke, we had our JNOV hearing. We went to mediation. Unfortunately, that was not successful. The plaintiffs have submitted a proposed form of judgment. And I think we are down to, obviously, Your Honor, we renew our request, our JNOV request that no judgment be entered in favor of plaintiffs on this case. But as to the form of the judgment, I think we are down to one issue, but it's a very big issue. And if I can, may I share my screen, Your Honor, and show?
Yeah, give me 1 second, please.
I'm sorry?
Oh, I said just give me 1 second, please.
Okay.
Go ahead.
Okay. There we go. Can you see my screen now, Your Honor?
Yes.
Okay. So,
If you want to come around to see better, by all means do it.
oh, okay. So the court will remember that the issue we have is this joint and several punitive damage submission. This is the way the punitive damages were submitted in this case. And that was, of course, a violation of the statute 41006, which says that punitives have to be submitted specifically against each defendant. They can't be submitted jointly. And at the JNOV hearing, there's no dispute about this anymore, that this submission was incorrect. Here's a transcript from the JNOV hearing. This is Mr. Bowman. And you know, I don't think he would dispute this, but I just wanted to remind the court of what we went through at the JNOV hearing. This is what he said. Now, we submitted our original verdict because Horizon and 41006 had not been considered. Horizon is, of course, the Texas Supreme Court case that says this is error. We did do it as a joint and several finding. I agree that joint and several is prohibited now by Texas law. It was prohibited at the time too, but there's no dispute that the way this was submitted to the jury is not the way that a judgment can be entered, that it was defective.
Your Honor, I actually object to misquoting me in this regard. I was referring to the judgment that we submitted that was erroneous, not to the finding. I do not believe that the finding is a joint and several, and I may have misspoken on this document, don't get me wrong, but we were talking about when we submitted the original version of our judgment, we submitted it as a joint and several. We then went back after it was first raised by the defendants that it was not allowed to be joint and several. They went back and looked at it and said, oh, okay, you're right, it's not. So that's when we changed that. But I don't think that this finding, and I certainly do not agree on the record that this finding is undisputedly a joint and several finding. In fact, we have argued over and over again, it is not joint and several. So I just
Your Honor, that we can go through the whole JNOV transcript, but it's pretty clear just from this snippet. When we submitted our original verdict, okay, not a judgment, a verdict, the verdict form, Your Honor, we did it as a joint and several finding.
Mr. Bowman, let her finish.
We did it as a joint and several finding. I did not believe there was any dispute that this, oh, sorry. Well, I'm going forward now. Shoot, how do I go back here? I'm sorry. Alicia, how do I go back? Oh, wait, I got it. Never mind. I didn't think there was any dispute that this finding, there can be no judgment on this finding. This finding is a joint and several finding. And that's precisely what Mr. Bowman said at the hearing. Your Honor, I'm going to go through this pretty quickly. That's what Mr. Bowman conceded at the hearing. And in fact, I think has conceded in the papers too. But no, anyway, okay. Well, here's their fix. So the question, Your Honor, is what do we do with this finding? What is the court to do with a finding that violates a statute? And, you know, the plaintiffs have said, here's our fix, Your Honor. Here's the judgment. Just pick one. Even though the jury found $10 million against party A and party B, we want you to just pick one because they know that they can't award it as the jury found it. So the problem with this remedy, Your Honor, is that it's rewriting the jury's finding. That's not what the jury found. This is the court making a new fact finding that the $10 million punitive damages award should be entered solely against one party. And the cases that we've given the court, and I'm happy to go through them, are very clear that the court can't do this. We are not permitted to speculate as to what the jury meant. When the jury was asked to award against two parties, we can't just pick one for the judgment. So, Your Honor, again, just to remind the court, this is the Texas Supreme Court, that the statute demands that a plaintiff secure a specific assessment. In that case, Horizon failed to obtain that finding. The court said Horizon had its chance to present its case and failed to obtain the findings required under Section 41006. And there was no objection in that case. Now, they will tell you that we've waived this. Their whole answer to this is we've waived it. But Your Honor, that's incorrect because there's a whole long line of cases and we've given them to the court in our various letters and findings. But here's the most succinct one. As for the contention that Sabine, that Lovelace waived complaint by failing to object at trial to the submission of the form of the damages issue, it's a very similar issue in that case. Sabine mistakes where the duty to submit separate jury findings on damages lies. An appellant cannot be held accountable for the failure of an appellee to secure separate findings upon which an accurate judgment could be based. And that's exactly what we have here. We have a finding which does not permit this court to enter judgment for punitive damages. So there's two choices we believe before the court. It's not to do what plaintiffs are asking you to do, which is just randomly pick one party. That's not what the jury found. So you can do it, you can just take no judgment for punitive damages. And that's what happened in the Lovelace Sabine case that I just quoted. The other option, we haven't moved for a new trial yet, but the court can grant a new trial, an entire new trial. And there's a lot of sense in that the punitives were something that infected the entire trial. And that's what happened, of course, in the Jenga case that the court raised to us at the last hearing.
Okay. And there's no way to do a new trial just on the issue of punitive damages?
You can't, Your Honor. I think that's Rule 320. You can't have a new trial just on damages.
Okay.
In most cases, Your Honor, where this kind of error happens, it's a new trial. That's the answer. We actually spent some time looking at this to see if we even thought a JNOV was possible, but the Lovelace case provides that model. When it's a severable issue like punitive damages, you just take the punitives out of the case. But we think also there's a basis for the court in granting an entire new trial on this point.
Mr. Bowman, I'm guessing you're not going to want a new trial.
No, Your Honor, I don't think that a new trial is necessary. As much fun as we had with the first one, we spent a lot of time and effort during a very trying time in this nation's history, obviously, in order to even secure a jury trial window. So no, I don't think that that's appropriate in this regard. And I also don't think that it's necessary. Frankly, did I misspeak when I said finding instead of submission of the order? Yes, of course. The rest of the entire JNOV hearing was me arguing ad infinitum that it is not a joint and several finding. That's why it does not say and or. Our position was that it was actually cumulative and that it's a $10 million finding against Brian Lee, and it's a $10 million finding against Walnut Creek Center, Inc. I believe that that can be read that way. Your Honor did not think that that was appropriate. And so decided, you're the one that came up with the JNOV fix of saying, well, I'm going to award $10 million in punitives against the company. Because
have there been any courts who've ever adopted your original proposal, which was $10 million for each?
We have never, Your Honor, we have not had a court. The answer to that question is no, it's just read that way. Honestly, I've never seen a court say that you cannot. And that is important because all of the courts that Ms. Johnson is citing that say you cannot and you may not and you shall not, all deal with scenarios where the verdict form did not include the name of the party to whom the judgment then subsequently assessed damages. In this case, that simply doesn't exist, and it's not a distinction without a difference. It's the whole difference. The whole point is that you want to be able to say, did the jury consider this defendant's culpability? And if so, what was it? And can we render a judgment on it? In this case, yes, they did. The jury considered the culpability of both Brian Lee and of Maya Walnut Creek for reasons that Your Honor believes are appropriate. You did not think that 10 million times 2 was appropriate under this finding. That's perfectly understandable. We accept a J&OV to say that it's against one party the 10 million stands, because it's a lost business finding of 12 million. So it's within the reasonable realm of you cost someone their entire business, so we're going to punish you for it. So, but twice the business, I can understand Your Honor saying that the jury went overboard on that. But in this case, the fix of saying that it goes against one party is an absolute cure, because that party is identified. It's identified in the finding with a dollar figure associated with that name. It's 10 million for Walnut Creek Center, Inc. There is no situation like there is in every single one of the cases that the defendants rely on, where the judgment would include the name of a party not on the finding. That's the whole point of it. The Jenga case, which is ostensibly the reason that we're now having what is realistically a second J&OV hearing, had absolutely nothing to do with 41.006. It had to do with specific findings related to negligence. But even there again, the settling parties in the Jenga case were completely omitted from the jury charge. And that was the nature of the problem. We don't have that issue here. In this situation, we've got the parties identified. The jury considered them and gave a number. And the court can clarify or cure any concerns about how much the punitive damages were by saying, I'm only going to award the punitive damages against the one party. And that cures any concern about excessive punitive damages by saying that it's 2 times the amount of the actuals. Other than that, we are not here based upon the Lovelace case. The Lovelace case doesn't have any bearing on this situation either any more than any of the other cases. It's not even cited in their motion. So what we are here for, Your Honor, is can we enter a judgment that can be upheld on appellate review based upon this jury charge? And the answer is yes, we can. The jury was unanimous. They found that these defendants acted inappropriately. They assessed a significant amount of punitive damages, very likely could have meant $20 million is what I believe they meant when they saw both Maya and, both Walnut Creek and Brian Lee. But if the court thinks that 20 million is too high, the court can certainly J&OV that down to one finding against one defendant. In this case, it'd be the company, because the company was the one that was the landlord. That certainly makes sense. But in this regard, the jury verdict can be rendered into an appropriate judgment, which is what we have submitted, of actual damages and actual punitive damages that are appropriately rendered, and then submitted into a judgment that we then go on and defend at the appellate level. It is not something that we require a new trial for. The cases that they cite simply vary and change upon the one most significant aspect, which is that they excluded the party from consideration by the jury. That is not the case here.
Ms. Johnson, do any of these cases you've cited to have the situation we have here where there were two people on the same blank?
Yes, Your Honor. That's the J&C. That's the J&C drilling case. What happened in that case, and I'm happy to pull it up and show it to you, but what happened in that case, Alicia, will you pull that one up and let's show the court the language in that case? The jury answered yes on negligence, and it submitted to the individual or the company, okay? And what the court said in that case is that was an ambiguous finding. And so you can see they said, did the negligence cause of A or B? And the court said that's an ambiguous finding. And the problem, Your Honor, with that is, okay, I'm sorry, I'm having, Alicia, can you drop it and then I can't
I
see
can
it.
see it fine.
Oh, okay, sorry. The problem with that, and I just want to point out the language that you just heard from Mr. Bowman about what he thinks the jury verdict mean. I think it means 20 million. I think it could also mean 10 million just on Walnut Creek. I mean, Your Honor, that just underscores the point of what the plaintiffs are asking you to do here. They are asking you to speculate about what the jury meant in an ambiguous answer. This is at best an ambiguous answer, but it's, I mean, at worst, it's a direct violation of a statute. And if I can just read section 41006, what that says: in any action in which there are two or more defendants, that's what we have here, an award of exemplary damages must be specific as to a defendant, and each defendant is liable only for the amount of the award made against that defendant. So when you combine two defendants on, you have not complied with 41006. And so where are we now? Plaintiffs are asking the court to guess, Your Honor, what this means. Guess that it means 20 million. Guess that it means 10 million just for Walnut Creek. That is precisely what the court cannot do. And that's exactly, Alicia, go to this language in J and C, if you can, where it says neither the trial court nor this court is permitted to speculate as to what the jury intended. Sorry.
They use that phrase more than once, I guess.
By an ambiguous answer. There we go. The evidence, the verdict does not clearly show that that is what the jury intended to find. The evidence supports a finding that Gonzalez was negligence, but the verdict form does not show that is what the jury intended to find. Neither the trial court nor this court is permitted to speculate as to what the jury intended by an ambiguous answer.
Ms. Johnson, though, the difference in this case, as opposed to the case that you're citing to J&C drilling, I guess, to what we have here, is that one was defendant A or defendant B. In our case, it was defendant A and defendant B.
Right.
That's true, Your Honor. I can see where defendant A or defendant B, there's a possibility that it shouldn't be against one or the other, but if we're just using logic, it would be defendant A and defendant.
Right, exactly. But of course, keep in mind again, Your Honor, that the judgment they are asking you to enter doesn't match the finding. The finding is A and B. And they're asking you to just award 10 million against B. That is speculation. Why isn't it against Brian Lee? I mean, we don't know. The answer is we're guessing here. We're guessing. And anytime you're guessing about a jury finding, how it translates into a judgment, you're out of bounds.
Are there any cases? What was the fact? What are exactly the facts of Horizon? Was it two defendants on the same blank?
In that case, Your Honor, it was the defendants. They added a defendant. No, it wasn't two defendants on the same blank, Your Honor. The way that it was submitted was the awards were assessed against the individual defendants, and then they tried to add in entities on a joint and several basis. So it was different. The actual submission was different, Your Honor. But again, this is a really unusual case situation, Your Honor. We're not going to find a case on all fours. What I'm telling you is we've got Horizon, we've got J&C drilling, we've got the Lovelace case, which is really the closest one, because there you've got a situation where they couldn't figure out the punitive damages because of the way the actual damages were all combined.
Ms. Johnson.
Yes.
So I've always respected you. I think you're one of the best appellate attorneys in town. I think you've been in my court many times. I always think you're very honest and forthright and professional. And so the question I have is, would I be better off from an appellate standpoint to do 10 million each then?
No, Your Honor, that's absolutely no.
That seems to be what you're saying, is that I'd be better off with 10, because we know that they intended to award $10 million.
But if they had intended that, then they would have awarded $20 million, Your Honor. They didn't award $20 million. But again,
well, maybe I should do 5 million each.
That's not what they awarded. Again, this is why you're trying to take a legally defective question that was not presented to you in a proper form
but there
and
was,
guess as to a judgment.
there hasn't been a single case that you've cited to, or that, I mean, I feel like we're kind of unknown.
Your Honor, all of our cases, I don't have the direct case that has these exact facts, but all of these cases go this way. And I would point out to you, you've gotten 0 from the plaintiffs in terms of a case that says you get to just pick one defendant or you get to just cut it in half. I mean, you can't do that, Your Honor. You have to enter a judgment based on the findings that were secured. And if the findings that were secured do not allow you to enter a judgment without speculating, there's no judgment.
May I respond, Your Honor?
Sure.
Thank you. I have not asked you to cut it to 5 million. I don't think that that's appropriate. What we are doing is not guessing. We are interpreting the finding. The finding says $10 million.
I think Ms. Johnson has convinced me that I either need to award 20 million, 10 million each, or 0. I mean,
that's what I wanted to say, Your Honor, because she's not right about that. Even the J&C case that she's citing to, where she's trying to say that it's the same, but obviously it's not because it was based on a disjunctive. The fact is that the court says that it cannot create findings of fact. It can only unfind them. So in this case, what you would be doing as the J&OV, which is frankly what I thought you had already decided to do, was you are unfinding the 10 million against Brian Lee because it's excessive or whatever the reason being, but you are keeping the 10 million finding against the other identified defendant. And it is the fact of identification in the question that is the distinction between all of the 41006 case law that they're identifying. All of the 41006 case law that they've identified specifically situated a situation where there is a non-identified defendant who then is subsequently given a judgment against them for exemplary damages, but they were not identified in the charge. That's the whole nature of the problem, because that's what the language of 41006 says. 41006 does not prohibit what we have done because it's not joint and several. It's just listing 2 at one question. The jury listed one number. It can be very easily, logically, and English interpreted that that one number applies to both of those defendants. That's a $20 million finding. It's within your Honor's power and judgment to decrease that under a J&OV to a single punitive damage finding.
Is that clear?
If you want to award 20 million, I'm not going to argue.
I mean, I kind of feel like Ms. Johnson has convinced me that I either need to do 20 million or 0. I mean, that's kind of
Your
where
Honor,
zero is not the answer, because the jury clearly didn't mean it to be 0. The jury meant this punitive damage award, and there is a means of interpreting it that is not what Ms. Johnson is trying to claim would be violative. That is the whole point of it. What we are trying to do is enforce the jury's will, because this jury came back very strong and unanimous against these defendants and said, you engaged in behavior that needs to be punished. And they awarded $10 million against one defendant and $10 million against another defendant. If we're not going to give it to both, we'll at least give it to one.
Your Honor, that's not what the jury awarded. There's no $20 million award in this verdict. And that would be such a target on this judgment. I don't believe Mr. Bowman even wants you to award it, which is why they withdrew it, and why they're now asking you to pick one.
That is not true. Your Honor, I'm frustrated at being misspoken about. I didn't withdraw it because I didn't want a $20 million award. That's why I submitted the judgment with 20 million. Your Honor, at the last hearing, said that you were going to consider doing the 10 million against the company. That's why we submitted it this way.
Your Honor, there's no basis for a $20 million punitive damage award. There's no finding, and we haven't even talked about the evidence.
10 million for each of them.
Correct.
That's not what the jury found, Your Honor.
Your Honor, Ms. Johnson wasn't here. She didn't understand how upset and frustrated and disappointed and how badly that jury disapproved of what Mr. Lee and that company did.
Ms. O'Connor, Ms. Baines, you were both there. Do you have any comments?
I mean, Your Honor, I would completely agree with that. I think just given all of the evidence that was presented, and I mean, Your Honor was there as well, and the jury was obviously, I would almost say outraged at the conduct of the defendants in this case, and quickly returned a verdict, I think quicker than either of the parties or Your Honor thought that they would, and it was unanimously in favor of the plaintiffs in their case. So I would agree with that.
Your Honor, I believe that the parties have overlooked the fact that one of the jurors didn't even find fraud before they went on a tear and issued a punitive damages award. There was something that went wrong, and this verdict form is part of what went wrong. Right now, it's completely ambiguous as to whether they intended $0 against the company and 10 against Brian, or the flip side, or if they intended 5 as to each. Whatever it was, Ms. Johnson's right that a judgment can't be entered on it because it is ambiguous. And it is an invitation at the Court of Appeals to overturn the judgment.
Your Honor, if I may, the problem that the defendants are posing to you is that they are trying to say by default, we have to go against what the jury affirmatively put in place. That's not the case. That's not the law, and that's certainly not appropriate for the courts trying to undo what a jury did. And here what we are looking at is, can we interpret this jury charge to be submitted in a manner that is correct? Not can we figure out a way that it can be interpreted incorrect? That's not the point. The point is, can we interpret it correctly? And the answer is, yes, we can. It can be interpreted logically and in English that a single $10 million was awarded against one defendant and a single $10 million award was awarded against another defendant. And Your Honor has the power within his decision-making to say, I think 20 million is too high. Or you can say, I think 20 million is what the jury meant, and I'm going to see if it's too high. And certainly you can enter a judgment for 20 million in full on punitive damages. That was what we originally submitted. Well, not originally, that's what we submitted once we realized that we had misinterpreted ourselves the charge. But that's not how it's done. It's not, can I interpret it wrong? It's, can I interpret it right? And the answer is yes.
Your Honor, I would just close by saying that we're in pure speculation territory here. There's no way to know what the jury meant by that answer, whether they meant 10 million to one, whether they meant 5 million to each. I don't think there's any way to interpret it that they meant 20 million when they wrote 10 million in the blank.
But we know that they meant 10 million.
They meant 10 million, but we don't know.
As to these two defendants, we just don't know.
Right, exactly. And so there's, but the problem is we have a statute that says that that can't be, you can't enter a judgment reflecting what the jury intended. So Your Honor, I just want to say back to you, I appreciate what a difficult situation this is. I really do. I do. And I understand that the court is hesitant to set aside a jury finding for all the right reasons. The problem is there's just no way for you to enter a non-speculative judgment based on this finding.
I honestly feel like that the only way that I can really reflect what the jury, given 41.06, the only way I can really do this is to enter 10 million apiece. I mean, I don't want to do that because I do feel that it's kind of excessive, but
Your Honor, Your Honor has the ability to, first of all, if you want to do that, I'm behind it. Obviously, I'm happy to take the 20 million because, as I said, I think that the jury very well meant that, and that it's certainly an interpretation that stands with what was on the written page. However, I don't agree that you have to. I think that you can J&OV that based upon your concern at the amount of punitive damages to a single award, because the interpretation is the same. It's an award of 10 million as identified by the jury against each of those defendants.
Why would it be just 10 million against defendant B and not defendant? Why would we not do 5 million apiece or something like that? Why does it need to just be against?
Well, it wouldn't be 5 million apiece because it'd be based upon the same interpretation of 10 and 10. You would be selecting which defendant you think that should have punitive damages awarded against them. And in that case, the reason I was saying, I mean, it could be against Mr. Lee if you think that's more in keeping.
Why
with
can't it be
doing.
5 apiece and JNOV it down to 5 apiece?
Because that is speculative, because they didn't write 5, they wrote 10. They didn't say that it's 10, 5 against one, 5 against the other. They said 10 million.
But you're JNOVing the $10 million. I mean, if we're really, if the argument really is, and I really do see both sides here. Thank you, Ms. Johnson, for, I can see what the argument, which should be 0. I also see the argument it should be 20 million. The only way I can see it being 10 million is if I say that it's supposed to be 20 million, but I'm JNOVing it down to 10 apiece, and I'm JNOVing it down from the 20, from the 10 apiece.
To an individual. Basically, what you would be doing is zeroing out the punitives against one and awarding them against
But
the other.
how would it be excessive against one and not excessive against the other?
Well, I think that the total amount is what the court would be considering. Don't be wrong. I'm not saying that you should discount it at all. I'm perfectly content to take the 20 up. I'm just saying Your Honor had originally said that you were comfortable entering the 10 million against the company. The company was the landlord, obviously, and that's who he was ostensibly working on behalf of. So if that was the reasoning that you think that the company should be the one to suffer, it also was the one that's likely got the assets going that we're going to be able to have to levy. I mean, there are myriad reasons to identify one rather than 2 individual defendants, but that's not the same thing as dividing the amount of the award. That's just identifying a specific award to a specific defendant that you are going to not consider, or you are going to consider. Dividing it to 5 and 5, that is different.
Your Honor, I would just bring you back to the question you asked at the beginning here is, where's the authority for this on their side?
Your court.
There's no authority for 20 million.
But
there's
really
no case that says you take that when there's a defective submission, that the remedy for that defect is to double it.
But there's also there's no cases that you've cited that says this is a defective submission.
Correct.
Yes, there are, Your Honor. Well, the statute says it's a defective submission.
No,
The language of the statute says an award of exemplary damages must be specific as to a defendant.
Correct.
This is not an award that is specific as to a defendant.
It is. It's a $10 million award as to Walnut Creek Center, and it is a $10 million award as to Brian Lee.
Your Honor, you know that that's not what this is. That's there that you see punitive damages submissions all the time that have one blank for a party and then another blank for another party. That's the way it's typically submitted. That's
Honor,
not what happened here.
If their legal support is, Your Honor, this isn't that.
Well, let's look at the
I would
pattern
bet you
jury
that they don't
chart.
have any legal support either.
The legal support, Your Honor, is section 41006 that says an award must be specific to a defendant, and each defendant is liable only for the amount of the award made against that defendant.
Correct.
That's the legal authority.
10 million against Walnut Creek Center, Inc. 10 million against Brian Lee. That is the way you interpret that finding in conjunction with 41.006.
And Your Honor, I'm just going to say, if we're going to interpret, I'm just going to say we're speculating. You should not have to interpret a jury finding. If it is not clear what the jury found, then you can't enter a judgment on it.
I don't understand or agree with that at all. That's the whole point of entering a judgment off.
Your Honor, that's what all of our cases say. That's what J&C says. That's what Lovelace says. That's what Jenga says, Your Honor.
That's not what they say. All of those cases say that you cannot add in a defendant to a judgment who was not considered in the charge. That is not what
that's
we have
Jenga.
before us.
That's not the other two, Ira.
That is absolutely what Horizon says. That is what
it's
all
not J&C and it's not Lovelace.
J&C was a specific situation where it was an either or. It is inherently ambiguous.
What was the last case that you referred to? There's one that I don't think I've seen.
This is the Lovelace case, Your Honor. This was the quote we had in the PowerPoint. Let me share it again, Your Honor, if I can.
Can you share the Lovelace case, Ms. Pitts?
Oh, yeah. Yeah. Why don't we just do that instead? Yeah, let's pull that case up. So, Your Honor, the situation in that case was they submitted liability questions on breach of contract, breach of fiduciary duty, and fraud. And the jury answered yes on all those theories. And then there was a single damages question. So and then there was a punitive damages question. So you can see where this is going. The problem was that the court could not tell from the jury findings that whether or not the jury's finding was for the breach of contract or whether it was for the breach of fiduciary duty and fraud. Okay. And so if you go to the language that say, because the court could not determine from these special issues the dollar amount, sorry. Oh, there it is. It's kind of in that paragraph under head note 12. It's right there in the middle. So you see from a reading of the issues and instructions, the jury was not instructed to make an award of punitive damages contingent on a finding of wrongful conduct under all of the theories. It was conditioned on only one of the theories. So then now
Is this a pre-broad form questions case? I can't tell.
Yeah, exactly, Your Honor. Well, it's where, no, there was a specific finding on each of the liability theories, but then there was one damage question. So if you start in the middle of that paragraph, the damages might very well have been awarded solely for the breach of the joint venture agreements. Furthermore, since we cannot determine from these special issues the dollar amount that was awarded for the torts, we cannot determine whether the punitive damages are reasonable. Okay, so it's a similar situation where we can't tell from this jury finding what the jury was finding on. Were they finding on breach of contract? Were they finding on fraud? Were they finding on breach of fiduciary duty? And what the court says is, we're not going to guess. We're not going to guess. And head note 13 is the point. As for the contention that this was waived by failing to object to trial to the submission of the form of the damage issues, Sabine mistakes where the duty to submit separate jury findings on damages lies. An appellant cannot be held accountable for the failure of an appellee to secure separate jury findings upon which an accurate judgment can be based. And yes, Your Honor, is it precisely the factual situation we have here? No, it's not. But there's no, this reasoning of when we have an ambiguous jury finding, we're not going to interpret it. We're not going to guess what it means. We're not going to make up what we think it means. That's not how courts handle that. And in Lovelace, the court just didn't award punitive damages. They awarded, I mean, let's keep in mind, this is a pretty sizable verdict without punitive damages. The court decided to not affirm the judgment as modified without the punitive damages because it couldn't tell whether the jury awarded made tort findings.
Your Honor, the Lovelace case is no more on point than any of the rest of their cases. I mean, it's not in their motion, it's attached to their letter at the end and cited for a totally different issue. The fact of the matter is the Lovelace, to the extent that there's an ambiguity, specifically an ambiguity, which doesn't exist here, related to actual damages in the Castile issue about you can't figure out which cause of action they're being applied to. That's not the situation that this case is. Now, Ms. Johnson is fighting tooth and nail, and I understand why. It's a lot of money. But so far, she has said every single case that she cites is exactly on point until we look at the case, and it is specifically not on the key distinction that Your Honor has picked up on in this case, which is the difference between being disjunctive or conjunctive, which does read to where you can say that 10 million was issued against both of them, one and the other, each the same dollar amount, $10 million. Two, you can't have a situation under 4106 with all the case law they've cited where you issue a judgment where the defendant is not identified, because that's not the case here. Each of those defendants was identified, and there's a dollar figure next to their name. That's the whole point. Can you take that and issue a judgment based on it? The answer is yes. Now, originally, Your Honor had thought that 20 million was too high and had suggested that you wanted to issue it against the company alone for $10 million. I believe that is within your power because you are still doing what the jury said, which is 10 million against against Walnut Creek Inc. That is on the jury's charge. What you're doing is you're J&OVing a punitive damage finding against the individual. If you at this time think that it is a better judgment upon review to issue 20 million.
Mr. Johnson, when does my plenary power expire?
Well, the clock on that hasn't started running yet, Your Honor. It doesn't start running until the court signs a judgment.
Oh, I thought everybody signed a judgment. No,
No.
No, Your Honor.
that's right. I sent it to mediation before.
Right, exactly.
Correct.
Yeah.
Okay. As a judge, anyway, that I'm going to take this under advisement. I'll try to sign a judgment by either taking out the punitive damages or doing one of the things we discussed by tomorrow.
Thank
Okay.
you, Your Honor. We
Thank
appreciate
you,
your
guys.
time.
Thank you.
Thank you.
Your Honor.
May we be excused?
You may.
Thank you. Have a good day.
Is anyone here on the Bostic case versus Baylor, Scott and White?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right,
Yes, Your
let's go on the record on cause number DC 1918052, Bostic versus Baylor, Scott and White. Council make your appearances.
Adam Simmons for Baylor, Scott and White, the movement.
Sally Metcalf here on behalf of Jerry Bostic, respondent.
Joshua J. Bennett here on behalf of the overhead door defendants.
Allison Lockhart for Door Control Services defendant.
And Todd Clement on behalf of the plaintiff as well.
All right, you may proceed.
Thank you, Your Honor. We were previously before you on a motion to enter a scheduling order, but the parties could not agree on whether new expert deadline should be in the new DCO. Once the parties continued the trial from, it was originally set in July 2021 to now February of 2022. Our current DCO is silent as to expert deadlines. Excuse me, and per the court's comments in that hearing, that previous hearing, Baylor, Scott and White, we now move for leave to designate an expert witness. Trial is still 4 months away. Plaintiff's counsel has not taken the expert depositions of co-defendants experts or even noticed them for deposition yet. Thus, there's no unfair prejudice for Baylor, Scott and White to designate its own expert. The only prejudice plaintiff's counsel could assert in response to our motion, and even at the last hearing, was the difficulty in scheduling other co-defendants experts for deposition. But that's not unfair prejudice as it relates to Baylor, Scott and White designating an expert. Rule 193.6 of the Texas Rules of Civil Procedure provides untimely evidence should be allowed if the court finds one, and only needs to find one of the following three things: good cause exists. Two, untimely designation will not unfairly surprise the plaintiff. Or three, no unfair prejudice. And just address the unfair prejudice part. Similar to that, plaintiff can show no unfair surprise. Plaintiff didn't even try to rebut unfair surprise in his response. We told plaintiff's counsel several months ago that Baylor, Scott and White intended to designate an expert witness when the parties were trying to agree to new scheduling order and new DCO. While plaintiff's counsel might have disagreed with us reopening the deadlines and designating an expert witness, it surely was not an unfair surprise. This was 8 months that we alerted plaintiff's counsel that we intended to designate a new expert 8 months before the new February trial setting. And finally, good cause exists for a late designation. Plaintiff's expert provided new opinion testimony after plaintiff's expert deadline and after his deposition. All the parties noted this in an agreed joint motion for continuance. So it was acknowledged in that. Baylor, Scott and White should likewise be afforded the opportunity to designate after the original expert deadline. Finally, as a side note, co-defendants counsel notified everyone several weeks ago of a conflict that might require another continuance in this case, which would give plaintiff even more time to conduct expert discovery.
Ms. Metcalf?
Yes, Your Honor. As far as our response under Rule 193, the party seeking the late designation has the burden to show the good cause. The unfair prejudice, the lack of surprise, and defendant has not done so here. The trial court has discretion to determine whether the offering party has met his burden of showing good cause to admit the testimony, but the trial court has no discretion to admit testimony excluded by the rule without a showing of good cause. And that's the Texas Supreme Court opinion in Alvarado v. Farah. Here, defendant has established no good cause. We have set this forth in our response, but Dr. Davis did not issue any new opinions. He provided additional information supporting his opinion that my client, Mr. Bostic, was in the detection zone alongside a door panel. The door failed to see him, began to close. We have offered it, what he did, Your Honor, and I can share my screen if you'd like to see it, but he provided an email where he said, okay, you know what? Well, let me see if I can share this. First, we've got his deposition testimony where they asked him, he was asked, how can you say if you don't know where he was before the door started to close, how can you talk about his position? And he talked about how he did know, he did have information about it when the door started to close. And so then what he did, Your Honor, let me see if I can pull this up as well. He wrote, need to stop share here. He wrote an email, and this has been provided to, let's see, just one moment, Your Honor.
I wasn't able to read what you showed earlier.
Oh, I'm sorry. Well, let's see if we can get that up first. Are you able to see this, Your Honor?
Yeah.
Okay, so
Where do you want me to start with?
The highlighted yellow portion. He was questioned during his deposition about his opinions and about his opinion that his opinion is Mr. Bostic was within this safety zone, this detection area. And so the door optic sensor should have seen him before it began to close. So then I believe this was actually counsel for door control services said, well, you don't know. She started questioning him about where specifically he was positioned in this detection zone. And he was answering, he said, well, you know, you can't get from, there's a point in here where, you know, he wasn't in the lobby. He wasn't somewhere else in the building. He was alongside the door, and he was alongside the door panel in the fully open position, which it had to get to before it could start to close. So he gave a general description. Then what happened, Your Honor, is after that deposition, Dr. Davis went back and performed some calculations. Let me see if I can pull this up. And do you see this, Your Honor? This is an email that he provided, and he said in the previous email, he determined approximately where Jerry Bostic would have been. And so then what he did is he went in and did a calculation based on someone's walking speed, based on the door speed, and did a more precise calculation for where Jerry Bostic was. His opinion was not new. It did not change. Jerry Bostic was within this safety zone when the door began to close on him. All he did was further pinpoint where in that zone he was. But because this was additional information, we agreed to allow counsel to depose Dr. Davis on this item, and we have agreed to that. We've said, okay, we'll present him again. You can ask him about this information. So again, I would say there's no good cause here. There's no good cause for defendant Baylor Scott and White's failure to designate experts back in April when their deadline came and went. The other defendants designated experts. Baylor Scott and White chose not to designate experts in April. Now, the other thing I wanted to address is the unfair prejudice. We have tried, Mr. Simmons is correct that we have not designated, we have not deposed their experts, but it is not for a lack of trying. We have been, I've attached emails. We have been trying to depose Mr. Lomas, one of the experts, since April. One of our treating physicians, I've given defendants 3 dates. None of them work for all of them. It's been a scheduling, frankly, a scheduling ordeal. And I'm hopeful we won't need to involve the court in motions to compel these depositions, but it is not for a lack of trying. We had a date, I thought, for Mr. Bennett's expert, Mr. Kringle, but then he said no, he didn't want to do that until, after these issues were decided. I understand that, so that everybody has all of the information, but those are the things that are causing this delay, not me sitting back saying, okay, we're going to just wait. That's not what's happened. We have been trying. The other piece to that, Your Honor, is my client is 82 years old. Putting off this case would unfairly prejudice him. Mr. Simmons has said, well, a continuance is the remedy to this, to allowing him to designate experts at this late juncture, but that would prejudice my client. We are set for trial in February. We hope to be in front of you at that time, Your Honor, but we have shown unfair prejudice. As far as unfair surprise, Mr. Simmons hasn't even told us what kind of witness this is. I don't know if it's a damage witness, if it's a liability witness. Yeah, we're surprised. We don't even know what this witness is going to testify about, what his area of expertise, his or her area of expertise is in. So yes, Your Honor, we have established those 3 things, even though it's defendant's burden to establish, it's actually their burden to show that what they're doing doesn't cause those things.
Mr. Bennett, you raised your hand, I think.
Yes, Your Honor, we're unopposed or even agree with Baylor, Scott, and White's motion. And I just wanted to speak to just a couple of things very quickly that Ms. Metcalf just mentioned that implicate us. One is this continuance issue. I gave notice. We haven't filed any motions yet, but I gave notice to everybody in the case. We are set for jury trial, specially set in Judge Tobolowski's court on January 25th in the Dallas pension and fire case, police and fire pension case. It's going to be a 6-week minimum trial. All parties agree on that. It's just how much longer than 6 weeks is it going to be? That starts January 25th. So I think it's too early yet, but there's no chance of settlement. This case has been there forever. The chances of settlement are very unlikely. The chances of going to trial are highly likely. Mr. Carter and I are both in that trial. We both have material positions in that trial. So there's just no, we'll be in trial still until Judge Tobolowski's court on February 22nd. So that's the point there that Mr. Simmons was alluding to.
When does the Tobolowski trial start?
It starts January the 25th, and that was continued from October. We were supposed to go to trial in October, couldn't get a jury and all that stuff. So
I will say
6 weeks would take.
I will say during COVID, trials seem to go a lot faster, especially if you're masked. So I wouldn't necessarily say that it's going to carry that long. Maybe it will. I'm not Judge Tobolowski. And if the parties want to agree to move it, I'm happy to move it. But I will say that I just had a trial where they said it would be 5 to 7 days, and I moved all the stuff around to accommodate them, and it was only 3 days long. And every trial I've had has been shorter than I think it would have been pre-COVID. I think partly because of the mask, and then people are just wanting to kind of get in and out. And so, but
I understand that. Even if we shaved off 2 weeks, we're still writing. Even if the trial was only 4 weeks and we shaved off 2 weeks and like 20 witnesses, each side's designated more than 20, we're still right at the week of this trial waiting for a verdict in that case. So I'm just putting it out there. A motion will follow as we get closer. We all know things happen, so I don't want to move too quickly or too early. But that's out there, and we've notified all sides to that. And I wanted to let Your Honor know that. And then in terms of the scheduling ordeal, I chafe a little bit at the implication that somehow it's the defendants that are being difficult here. I have given Ms. Metcalf dates for Mr. Kringle 4 different times, and she's turned me down every time. And the most recent hangup is because I wanted to pose, I have a rebuttal expert. And so it makes sense that for my rebuttal expert to supplement his opinions, we needed to depose Mr. Davis about his supplemental opinions first. And I tried to get his deposition, but Ms. Metcalf said I couldn't get it until this issue was resolved, which of course then set my person's deposition back. So she's mentioned in motions to compel as though she needs them. She doesn't. We've all been trying to work together here, and I take issue with any implication that we've been difficult in trying to get things scheduled. That's not the case. My last point, just real quick, is there's no prejudice here. There's no surprise. And the reason I'm concerned with that is for the reason you just heard. We heard a lot about apportionment in the hearing before. I'm up in front of the Texas Supreme Court at the end of the month on a case where I'm arguing that just because a co-defendant's judgment got reversed doesn't mean I should have to retry my case. We'll see what the Texas Supreme Court does on that. But I don't want to go back for a new trial just because somebody way down the road in Austin concludes that Baylor, Scott, and White all along should have gotten their expert in. There's been no show of prejudice. There's been no Mr. Simmons has shown there won't be any unfair prejudice or any unfair surprise. Ms. Metcalf's only retort to that is it's just too hard to schedule things. And with all due respect, that's just not a cognizable form of prejudice or surprise. No court, no case that I know of or that she cited has recognized that.
Mr. Bennett, it's not your motion, so I don't mind hearing about your other issue, but I think you're trying to kind of jump in on Mr. Simmons, and it's not. I don't think it's your motion, right?
It is not. I've joined it. I've agreed to it. I endorse it.
Okay.
And I will say, Your Honor, I obviously appreciate Mr. Bennett, and I would reiterate those same things.
Mr. Simmons, I guess my question is, why didn't you designate this? So when was this email that she just showed?
Of the supplemental opinions?
Yeah.
Ms. Metcalf may have to bring that up. I know that we have on our joint motion for continuance that everybody signed back in June, we specifically noted that due to a recently supplemented expert report by plaintiff's expert, which was served after the deposition of plaintiff's expert, defendants will need to redepose plaintiff's expert on the recently supplemented opinions. So I would anticipate that the new opinions came in June or May.
Your Honor, the email that I provided was May 12th. And, again, we will urge that these are not additional opinions. These are.
And when did Mr. Simmons, have you designated this new expert or just asking for leave now?
We're asking for leave, Your Honor. We after everybody agreed to the joint motion for continuance back in June, the trial was originally set in July. We agreed to a new trial setting, and Baylor, Scott, and White circulated a new DCO that would reopen the expert deadlines. We told Ms. Metcalf that we intended to now designate an expert. Now that the trial has been pushed back 8 months away, she disagreed, said, no, I won't agree to that. I won't reopen deadlines. You've had your shot. No, even though we were 8 months out. So we came to you previously in a motion to enter a new scheduling order with competing scheduling orders, if you will. And ours had a new deadline for experts. Hers did not. And as you indicated, let's just get one that we can agree to. And you said, Mr. Simmons, why don't you come back with a new motion for leave to designate experts? And so that's what I'm here doing now. But she's known that we wanted to designate an expert since I pulled up my email since July. But she didn't agree to it then. So I find it hard to believe that she would say that she's unfairly surprised or unfairly prejudiced when she was adamant that she would not agree to.
Okay, I'm going to go ahead and grant the motion, but I'm going to require you to make the designation by this Friday, and I'm going to require there to be a report by the Friday after.
Okay.
Failure to do either of those timely will result in the expert being struck.
Understand.
And I at this point, I'm not, unless there's agreement, I'm not moving the trial setting, but I'm we need to have a proper motion and discuss that. So, Mr. Simmons, go ahead and prepare an order on this. And then also you need to provide deposition dates by Thanksgiving for this expert. And I guess all these other issues, if for some reason I share Ms. Metcalf's concern if her client is 82 during COVID, that we need to get her case to trial. So I understand there may be an issue with Mr. Bennett's schedule, maybe, but I would not expect there to be a continuance unless Mr. Bennett's still in trial. And so we need to get this case to trial. So let's get everything done that we need to get done before get this case moving. So, all right, Mr. Simmons. So at the beginning of your order that you're going to submit, if you could make sure that it says on November 8th, 2021, that this hearing was held as opposed to on this date. Share it with Ms. Metcalf to make sure that she doesn't have any objections to the form of the order, that it contains everything we discussed, and then send it to, and then you could e-file it and then email it to Rhonda, my court coordinator.
E-file it and email it to Rhonda.
Yes. Thank you, guys. You guys have a good day, okay?
Thank you, Your Honor.
Thanks, Your Honor.
Next case is Abbott and Associates. Are the people for the wedding here? Oh, I didn't know that. Tell them to come in. I'm sorry, we need to take a break. Okay, everyone, can you guys hear me okay?
Yes, Your Honor.
Just had a lovely wedding with a very pregnant bride. She's due next week. So I'm glad we got this done without any issues. So, all right, well, let's get started. We're here on the Ben Abbott and Associates versus Angel Reyes case.
Yeah, Your Honor, this is John Gerhardt for Mr. Abbott, the plaintiff.
Let's go ahead and go on the record on this. Let's go on the record on DC 215441, Ben Abbott and Associates versus Angel Reyes and Associates. Counsel, make your appearances.
Your Honor, this is John Gerhardt and Grayson Linyard of Hunt Andrews Kurth for the plaintiff, Ben Abbott and Associates.
Good morning, Your Honor. It's Chris Schwegman for Angel Reyes and Associates, PC.
Let's proceed.
And Your Honor, by the way, I think your video screen's still off on your computer.
Oh, it is. Oh, you're right. Sorry about that.
No problem. Well, there you are.
There I am. Okay.
Well, now you're
What is
back
going
on.
on with my, there we go. Okay. Let's go ahead and go.
Thank you, Your Honor. This is John Gerhardt. We're the plaintiff movement today on a motion to compel discovery. If you don't mind, I'll share my screen with you and kind of give you a rundown of what we're here about today.
Sure. And I'm very familiar with this case and I have read the briefing, but I'm not exactly sure what we're still fighting about.
Yes, sir. Can you see my share screen?
You may.
All right.
I do, yes.
You know, Your Honor, so let me get back over here. Your Honor, I mean, and you said you're familiar, so I'll be brief, but you know, this lawsuit's about false and deceptive advertising that Mr. Reyes is utilizing to try to poach clients from Mr. Abbott's law firm. And we've sued on two basic schemes. One we call the lawyer referral scheme, and that's the one on the left here, where Mr. Reyes uses what we call these intermediaries. You could call them lawyer referral services, but they're these websites that are very vague. They're very vaguely named. They're very cryptic as to who they are. And they don't even let a customer click through to the website. What they do is they put these on mobile ads where the customer who's trying to look for Mr. Abbott types in Ben Abbott and Associates, for example. This pops up, an ad of this nature that I'm showing you, pain and suffering calculator, how much is your accident worth, pops up above Mr. Abbott's ad. And then all the user, if they think that's Mr. Abbott, all they can do is click the click to call button down here where the phone number is. And then that prospect's been diverted to Mr. Reyes' call center, who engages in further deception to try to convert that prospect to a client for the Reyes firm. The other side of this scheme is what we call the false advertising scheme. That's where Mr. Reyes and his partners advertise on their own website, Reyes Law. They again purchase keywords, Mr. Abbott's keywords, where if somebody on his mobile phone is searching for Ben Abbott, at times the Reyes Law website will pop up, the ad will, just like you see here on the screen, and make a host of unsubstantiated misrepresentations that violate state advertising rules. For example, here you see he's talking about a 98% success rate. And it's the #1 accident lawyers in Dallas. And again, uses this click to call function where the user can only click on a button to call the Reyes firm to talk to Reyes intake personnel.
Can I ask a question here about this?
Yes, sir.
Do these come up as one thing, like the call 866-625-6990? Does that come up as one, I don't know what it's called, entry when you do a Google search, or is that two different entries?
That's one entry, like the one you see on the screen right here, this injury.com ad that you see. This everything above Ben Abbott and Associates is one advertisement right here.
Okay, but
on the screen.
It is the 866-625-6990. That is Reyes's law firm.
This would be a call to the intermediary website operator who then directs it to Reyes's law firm. This
Okay.
ad over here that I just flipped the screen back to, where it shows Mr. Reyes' firm, it says 866-528-0655. That's a call to Mr. Reyes. All right. But in both instances, the callers are directed to the Reyes law firm when they are searching for Ben Abbott's law firm. And what, the courts are real clear that, this is known as initial interest confusion, which I put up here on the screen here, a Fifth Circuit case that talks about it. It basically says, initial interest confusion is confusion that creates initial consumer interest, even though no actual sale is finally completed as a result of the confusion. So what can happen is, somebody can call, be confused, end up with Mr. Reyes, and then Mr. Reyes gets his shot at him, either through false representations about his success rate or whatever else. But he got that call through initial interest confusion, which is actionable, and which in part we're complaining about. Now, regarding these ads about some of the things that he claims, this is straight out of the state bar files. Mr. Reyes has been told by the state bar not to make these kind of claims. Okay. These are the handwritten markings from the Texas State Bar file telling him that these ads are false and misleading, and things of that nature, and rejected ads of this nature when he submitted them before. But he's still using them in ads on the internet. And that's part of our claim, is that these are false and deceptive ads that give rise to a claim for tortious interference in favor of the Abbott firm. Now, if you've read the defendant's response to our motion, they basically rehashed the arguments that they were prepared to make to you back in August on a motion to dismiss, saying there's nothing wrong with this, judge. This is just like everybody else. They cite our friend Clay Jenkins and what his ad website looks like. We're not talking about what Mr. Jenkins did or anybody else. What we're talking about here is a scheme where Mr. Reyes and his firm uses these vague, intentionally vague and obscure intermediary websites to trick people into thinking they're contacting Mr. Abbott to get first shot at. Two courts, both the Fifth Circuit Court of Appeals and the Northern District of Texas, have both rejected arguments by Mr. Reyes' counsel claiming that there's nothing wrong with these things, with these tactics. They have both said in lengthy opinions that in fact these are actionable. You don't have to read it, but Judge Boyle, in a case that Mr. Abbott filed against one of these law firm referral services, agreed with Mr. Abbott that these claims are actionable. The Fifth Circuit, in a case that Jim Adler brought against another website operator, also represented by Mr. Schwegman, also found that these claims are actionable. It's not the mere fact that they purchase keywords and pop up above Mr. Abbott, it's the tactics they use and the confusion they engender that's what's actionable here. And Magistrate Judge Horan even issued an opinion last year that noted that these claims also are actionable as tortious interference, which is what we're talking about here. That's one of our claims, Your Honor, is for tortious interference. Now, getting to the issues that we're here for today is there certain categories of documents that we think we're entitled to that Mr. Schwegman, on behalf of Mr. Reyes, they haven't agreed to provide us. In the first category, which you'll see on the screen here, relates to interrogatory number 3. We are seeking information about the various intermediaries that Mr. Reyes is going through to place these ads. They have responded with respect to one website called lninjury.com, but they're refusing to provide us information of these other intermediaries. But that's the basis of our complaint, Your Honor. We say in paragraph 2 that Mr. Reyes and his firm conspire with the operators of these third-party sites to direct customers to his business. So we simply want them to identify who those intermediaries are. We know some of them. Frankly, we've sued 1 or 2 of them, but there's others out there we don't know, and we're entitled to know who they are. It's not unlimited in time. It's only for 4 years. From the date of the petition, and it's something that the Reyes firm should be able to provide us quite easily.
Response? And let me just say this. I've heard this argument before. I don't know that it's really about the basis of the claim. I'm really just trying to get down to the motion we're here today, which is what's on the screen.
Yeah, I'd appreciate that, Your Honor. For a second, I thought I was in a different hearing. This is
Yeah.
as you know, a motion to compel, not a summary judgment or special exception. I'll focus on what Your Honor's asking about, which is the identification of these other intermediaries. Your Honor, the problem is that the request is overly broad, it's irrelevant, and it represents an improper fishing expedition. The text of the interrogatory asks Reyes to identify any other intermediary the firm used, including the dates and duration of time. Now, the problem here, Your Honor, it's twofold, but the first is that Abbott defines an intermediary as any lawyer referral service, any lead generator, any third-party website, or any other advertising or marketing service that uses internet advertising to refer or provide information about clients. The basis for all of the claims here are internet referral services that use keyword advertising off Abbott's name to generate an advertisement that appears before or at least higher on the screen than Abbott's advertising or website address. The problem here is that the scope of intermediary is defined too broadly to include any type of lawyer referral service that the Reyes firm may have a partnership with, whether or not it uses keyword advertising or not. And it's particularly troublesome because Abbott wants the list, and Abbott's a direct competitor of Reyes. So the first issue is just overly broad. It far exceeds the scope of what's actually at issue.
All right, so I'm going to allow the any intermediary that allows keywords that I don't know if you said allow, uses keyword searches as part of their marketing. So interrogatory number 3 is limited to just intermediaries who use keyword searches, but those will need to be provided. Next one.
Thank you, Your Honor. And by the way, Your Honor, we sent you a notebook late last week that had a checklist order in it. I don't know.
Oh, you did? I don't think I have that. Let me, whose name is on the front?
The notebook?
Yeah, no, I'll go find it. Just give me a second.
Yeah. We sent it down Thursday afternoon. I apologize for not pointing that out earlier.
I can't find the notebook. I apologize.
All right, Your Honor, we can send you down another, we can,
Did you e-file the checklist order at least?
no, we put it in the notebook that we hand delivered.
Okay, I apologize. I just can't, I don't see it here.
That's all right. My apologies. We'll send you down one that tracks your rulings.
Okay,
Um,
so the next one,
Yes, Your Honor. The next category really is bullet points 2 and 3 here on the screen. It's interrogatories 1, 4, and 5. I think they're all related. What we're seeking is information regarding potential clients referred to Reyes either through these intermediaries, which is 1 and 4. 1 focuses on lninjury.com, who was a defendant in this case originally. And 4 focuses on any other intermediaries. And interrogatory number 5 focuses on any potential clients obtained by Reyes through his false advertising scheme, where he's making these 98% success rates and whatnot representations that users are seeing when they search for Ben Abbott. And so what we got from them, they objected obviously and said, confidential and attorney-client and whatnot. And they gave us fairly useful list. This is what they gave us. If you can see it on the screen, it's the slide that says information produced regarding leads obtained by Reyes. So they just gave us these nondescript entries of people that either contacted Reyes through this LN injury site or through the false advertising under the Reyes website. We can't tell who they are, what their demographics are or anything. And you'll notice some of them were signed up. Many of them were dropped or turned down. I don't know if that means turned down by the client turned down Reyes or Reyes turned down the client, but this is all we have. So what we're seeking, if you look at the request, and I can put this on the screen for you just to give you an example from interrogatory number 1, we're wanting the basic contact information for each client, potential client, referral, or lead. And then the information on any lawsuit that was filed, the status of that lawsuit, and any amount received as a result of settlement or judgment. All information that they have, but which they haven't provided us. Now, the principal argument they make seems to be, well, this is privileged, but it's not. And it's not for several reasons, Your Honor. One, let me show you this screen here. Clearly, people that called Reyes and did not engage Reyes are not clients of the Reyes law firm. So there's no privilege at all there. And then even if one of those individuals did retain the Reyes law firm, it's pretty clear under the law that client identity is not privileged. The substance of a communication back and forth between a client and a lawyer might be privileged, but the mere fact that somebody is that lawyer's client is not normally privileged. In fact, that's normally what you see on privilege logs, for example. And really what we're seeking here, Your Honor, is, well, let me say one third thing there too. Plus, Reyes has disclosed the identity of most of these clients in any lawsuits he filed, any demand letters he sent, things of that nature. So there's nothing really secret here, okay? We're entitled to be able to contact those people to see if they were confused by the advertising. That would be indicative or an indicia of confusion through these ads. There's nothing that we're trying to get this that would be, trade secretive of any nature. And there's a protective order in place that's been submitted to the court. So, we see there's no harm in providing this information. It's highly relevant to the case. It goes to the actual confusion that was generated by these ads. And we ask that you grant our motion as to interrogatory numbers 1, 4, and 5.
Your Honor, we provided them in an effort to compromise a spreadsheet that provided the number of leads that we received from linjury.com and from Abbott's own advertising. We gave them the number, where they're from, whether they were signed up, or whether they went elsewhere. I generally agree with Mr. Gerhardt that identity information isn't privileged. I'm not particularly concerned about that. It's just in the meet and confer process, they made absolutely clear that once they have the contact information, they intend to contact all these people and interview them. And that's where we run into problems, Your Honor, because we think, well, first, we think it's highly improper for them to contact and interview Reyes's current clients, his existing clients, because that will almost certainly lead to the inadvertent disclosure of privileged information, to say the least. I mean, it's also invasive and confusing and potentially disorienting for those existing clients. With respect to either clients that didn't sign up or that were turned down for one reason or another, it's essentially the same problem, because what Mr. Gerhardt and his team went to ask these people about are those initial conversations that those folks had with Reyes and his law firm. And those client consultations are all very much privileged, whether Reyes chose to take the case or not, or whether those clients chose to go elsewhere. And so we think because of the very high probability that these contacts will lead to the inadvertent production or disclosure of privileged information, that request is just a step too far and it's disproportionate to the needs of the case.
Your Honor, if I could add.
Okay, so what? No, I'm going to go ahead and rule on this. I'm going to allow the information, the name, contact information, case style, financial outcome to be produced for anyone who's an existing client of the Reyes law firm. Though that needs to be noted, and you are not allowed to contact them directly. You can attempt to take their deposition or something like that, discovery in some other ways. But any current clients, I agree that the likelihood of any type of privilege being waived is too risky, and so those folks you're not going to be allowed to contact. And you don't have to provide the contact information. Just say they're a current client and they can be contacted through counsel.
Thank you, Your Honor.
Thank you, Your Honor.
Does that deal with 1, 4, and 5?
Yes, sir.
Now, it wasn't clear about 52 and 54. Are these recording conversations between the client and the lawyer referral services?
No, Your Honor, it would be recordings of conversations with the Reyes law firm intake personnel and these potential clients. Now, these are a bit odd. We requested these communications and we got back a number of objections from Mr. Reyes' lawyer, Mr. Schwegman. And then we met and conferred on these requests and they maintained those objections. And now in a response they filed a few days ago, they say, well, they don't have any recordings, which strikes me as somewhat odd, that if you didn't have any recordings, why would you have made all these objections and why would you have maintained them in a meet and confer? But, I think this can be, if they truly have no recordings, I think the court can just grant our motion, overrule their objections. They have said they will amend to say they don't have any responsive documents and we can move on, if that's the case.
Well, Mr. Gay, I got to correct something, because request for production 52 and 54. 52 says all recordings of any client communications with any client, potential client, referral, or lead that you obtain from linjury.com operators. And then 54 is the same thing with respect to some other intermediary. These two requests don't refer to Reyes client recordings at all. And I think there was some confusion either during the meet and confer process or in the process of preparing these motions, but we don't have client recordings of that were maintained by the intermediaries. What's more, Your Honor, I don't think that the court can just easily grant the motion, because these are initial client consultation calls. And there's no question that they involve clients saying what happened and that information being taken down, and that's going to have privileged information in it, more likely than not.
Okay. So I'm a little unclear. Are you requesting conversations, if there's any recorded conversations with the lawyer referral service, is that what you're requesting, or with Angel Reyes's office?
Yes, Your Honor, to clarify, this is any recordings in the Reyes law firm's possession with potential clients that were referred to them through either one of these lawyer referral services.
The objection to that is sustained.
Your Honor, could I ask, hear me on one point on that?
Okay.
Most of these people did not retain the Reyes law firm. They were talking to an intake person and they went on their way and did not retain the Reyes law firm. So there's no attorney-client privilege relationship. And at a minimum, those recordings should be produced. Because, and I hear you, if there is a Reyes client, they have a heightened concern, just like you made in your other ruling there. I understand that, but most of these clients went on their way without hiring the Reyes firm.
So if there are any recordings of, I understand that argument. If there are any recordings of folks who did not end up hiring Reyes, if those exist, then I want you to create a privilege log as to that. As to those recordings. Does that make sense?
It does, Your Honor. We'll do that. Client consultations, in my experience, are privileged, whether or not the lawyer's ultimately retained or not. I've had, as the general counsel of my firm, I've had to conflict out of cases, even where my firm didn't take the case, because we sat and consulted with someone who either chose to go somewhere else or because we chose not to take the case. The fact of retention is not what's determinative here. But I understand Your Honor's ruling, and we'll endeavor to comply.
I'm not ordering you to produce any of them. I'm just saying you need to do a privilege log to identify any of those that you have.
Understood.
If any. It sounds like you may not have any.
Thank you.
Anything else, guys?
Yes, Your Honor, there's a few more requests I put up on the screen for you. The next two are request numbers 34 and 36.
I'm sorry, I stopped the share screen, so I thought you were done. So go ahead and share screen again.
You have it?
Yes.
So request 34 and 36 seeks scripts and written procedures they use on dealing with potential clients referred to Reyes through these lawyer referral websites. Again, objections were made to both these requests, and there was one script that has been produced that we have. But these objections suggest there are other scripts that we don't have. And again, our request covers 4 years, covers from 4 years from the date of the lawsuit. So if there are other scripts that have been used either contemporaneously today or in the past of the last 4 years to divert customers, we would like them produced.
I apologize. We're really out of time, so I'm going to have to rule on these fairly quickly. So the scripts are, you've already produced them.
Your Honor, we produce the script that we use. We don't have scripts that the intermediaries use.
Okay.
Your Honor,
To the extent you have those in your care custody control, you need to produce them.
Okay.
And so if they're in your care custody control, for interrogatory number 8, the objection's overruled. That'll need to be produced. Objection, interrogatory 13, that objection's overruled. They'll need to be produced. For request for productions number 83 and 93, I'm not sure I understand it.
Yeah, Your Honor, Google gives these advertisers reports and data sets that relate to the click-through and the success rate on their advertising campaigns. And that's what we're seeking. They're common reports. And what Mr. Reyes and Mr. Schwegman gave us was a spreadsheet that they created, trying to distill down the information instead of giving us the raw data that shows the success rates. I mean, they have, by their own admission, they have a Ben Abbott campaign. You know, they target Mr. Abbott's clients with ads. If you can see on the screen, they gave us this showing all the keywords associated with Ben Abbott that they run as part of a Ben Abbott campaign. It's 143 terms, all right? What we're asking for are the reports they get from Google and the success rate on their ads. And these requests are limited to using these lawyer referral services or using plaintiff's marks, meaning the Ben Abbott marks, in advertising campaigns. And that's all we're seeking.
I get it. Objections overruled. The request for productions number 83 and 93. All right, guys, get me an order on this. Make sure that you include at the beginning of the order that it's going to be that it was heard on November 8th, 2021. Go ahead and produce that to the other side. Share that with the other side before submitting it to me. Email it to Rhonda and e-file it as well.
Thank
All
you.
right, guys, thank you so much. You guys be safe. Oh, and let's say that these need to be produced within the next 21 days. And there is no attorney's fees if there was a request for attorney's fees.
Thank you, Your Honor.
Thank you, guys. You guys be safe.
Okay, thank you, Judge.
Smolinski versus Dallas Central Appraisal District.
Smolinski is present, Your Honor.
Hello.
Present for the appraisal district, Your Honor.
Mr. Metcalf, I didn't see a response to his motion, and I think that might be because it was set so quickly, but I'm not sure why you didn't respond.
We also have the employee who is in question is retiring and will not be available for trial. So we intend to withdraw her and any other additional experts that he's complaining about.
So you're withdrawing all of the experts?
Yes.
Okay. Tony, let's put that on the record then. Let's go on the record on DC 2100507. Gregor, I'm not sure how to say that. Smolinski versus Dallas Central Appraisal District.
Gregor Smolinski, yes, Your Honor, that's the first name and last name.
Mr. Metcalf, make your announcement.
Braden Metcalf for the Dallas Central Appraisal District.
And as I understand it, you said you were going to withdraw any of the experts being challenged by the plaintiff in this case.
That's true, Your Honor. The primary expert and the only one we're going to use is going to retire, and we don't have reports from any of the others, so we will withdraw those formally here today.
Okay.
Some of them were disclosed as fact witnesses, and obviously that wouldn't